Welcome to the Deep Dive. Today, we're tackling something that sounds maybe a bit dry, but is actually super important. The State Land Disposal Act 48 of 1961.
Absolutely. It doesn't exactly scream excitement, does it? But this act is, well, it's fundamental for understanding how the government manages, controls, and sometimes lets go of, huge amounts of land.
Right. It's the rule book for all that state-owned property. And we're talking about a law from 1961.
Assented to June 19th, commenced June 28th, 1961. A long time ago.
But the fascinating thing is, it's still here. It hasn't just faded away. It's been amended, updated, even quite recently, right? Late 2024.
Exactly. That tells you something about its core structure. It's adaptable, or at least successive governments have found it necessary to keep adapting it rather than replacing it entirely.
So what's its main job? What's the mission statement, so to speak?
Well, it's kind of twofold. First, it lays out the ways the state can actually dispose of its land. That means selling it, leasing it, exchanging it, donating it, getting it off the state's books or into use.
Okay, disposal. And the second part?
And this is really crucial. It specifically stops people from acquiring state land through what's called prescription, basically claiming ownership just by occupying it for a long time.
So it's got an offensive capability, getting rid of land, and a defensive one, protecting the land it wants to keep.
Precisely. That combination is key. And, we're trying to make this clear for everyone, whether you're just curious or maybe even studying law. We'll hit the key legal points, but keep it understandable.
Sounds good. So let's start with that core power, the disposal part. That's mainly in Section 2.
Yes, Section 2 is really the heart of the disposal mechanism. It puts enormous power, initially at least, right at the top with the president.
The president acts as the custodian then?
Essentially, yes. The president is empowered to act on behalf of the state regarding its land.
And Section 2 lists the main ways. You mentioned sell, lease.
Correct. It explicitly allows the president to sell, exchange, donate, or lease state land.
Okay, standard enough. But there's usually a catch or some key wording.
Oh, absolutely. The kicker is the phrase, on such terms and conditions as he may deem fit.
Deem fit. That sounds very broad.
It is. It's a huge amount of discretion. It allows the government flexibility, to set specific conditions on a sale, perhaps, or offer a lease for a particular purpose. It's not just a simple transaction.
So if the power is that broad, deem fit, what stops it being used, improperly? Are there built-in checks?
There are some important limitations within Section 2 itself. For instance, the president generally can't dispose of land if its disposal is already specifically covered by a provincial ordinance. So provincial law can take precedence in certain areas.
Okay, so it respects existing regional rules sometimes.
Yes, but then there's an exception to that exception, which is quite specific.
Okay, let's unpack that.
Even if a provincial ordinance normally governs disposal, the president can still step in, but only for leasing certain types of public land.
But which types?
We're talking about things like public resorts, places for recreation, or sites deemed historically or scientifically important. Basically, if the provincial law doesn't allow for leasing of these specific public interest sites, the national power under this act can override that just for leasing purposes.
Interesting. So it ensures nationally significant public spots can still be leased out, even if local rules are restrictive.
Exactly. It carves out a specific national interest there.
Now, let's talk about something really practical that comes out of this section. You mentioned a deeds registry twist, subsections 2(a) and 2(b). What's that about?
Right. This is where it gets into long-term control, even after the land isn't technically state land anymore. The minister, who usually gets these powers delegated, we'll get to that, can tell the registrar of deeds to put a note, an endorsement on the title deed.
A restriction, basically.
Yes, a restriction on the state land being sold or alienated. That's fairly standard. But here's the twist. The minister can also authorize that same restriction to be placed on other immovable property that belongs to the person or entity receiving the state land.
Wait, on their other properties, not just the land they got from the state.
Correct. So say you buy a piece of state land under certain conditions, maybe to build affordable housing. The minister could potentially put a restriction on the sale of your other unrelated properties, making it difficult to sell them separately without consent.
Why would they do that? That seems quite intrusive.
It's a powerful enforcement tool. It ensures the buyer sticks to the conditions under which the state land was transferred. If you got the land cheap because you promised to build that housing, this stops you from just, say, selling off your other assets and walking away from the obligation on the state land. It ties your broader financial dealings to the promises you made regarding the specific state land parcel.
That's a serious level of control extending beyond a specific transaction.
Okay, so that's about managing land disposal and future use. What about the defensive side you mentioned, protecting state land? That brings us squarely to Section 3. This is the Act's shield.
And it deals with prescription. Can you remind us what that is?
Sure. Prescription, or sometimes called adverse possession, is a legal principle found in many systems. It basically says if you openly occupy and use someone else's land for a long, uninterrupted period, often like 10, 20, 30 years, depending on the law, as if you were the owner, you can eventually acquire legal title to it, even if you didn't originally own it.
So use it like you own it for long enough and it becomes yours.
In simple terms, yes. It rewards actual use over just paper ownership sometimes.
But Section 3 says...
Section 3 says a flat no to that concerning state land. It states very clearly, notwithstanding any other rule of law, that state land cannot be acquired by prescription. There was a short grace period after the Act started in 1961, but after that, the door slams shut.
So no matter how long someone camps out or farms a piece of government land, they can never legally claim it that way.
Never. It secures state assets against this kind of loss permanently. It's a really strong protection.
That makes sense for protecting parks or military bases or whatever.
Ah.
Now, the Act also seems to deal with situations involving private land, not just state land. Section 2A.
Yes, it's not just about the state disposing of its land. Section 2A handles situations where the state might hold certain rights over private land, often due to historical agreements or reservations in the title deed.
Like what kind of rights?
Could be an old right-of-way the government needs, or maybe mineral rights that were reserved when the land was first granted generations ago. Section 2A gives the president the power to agree to cancel or amend those old conditions if they're no longer needed.
Or to actually use them.
Or to actually exercise that right if necessary. It provides flexibility to manage these lingering historical entanglements on private titles.
And speaking of specific situations, Section 2B mentions the Cape Town foreshore. Why does that get a special mention?
The foreshore. It's a unique case. Much of that land was reclaimed from the sea and became strategically important for Cape Town's development. An earlier act from 1950 dealt with it vesting in the state.
So Section 2B just confirms it's state land under this 1961 Act.
It does that, yes. It formally brings the foreshore land under the umbrella of this act as of 1979, but it also adds a specific financial arrangement.
Which is?
It allows the minister to actually pay some of the money generated from selling or leasing foreshore land directly to the City Council of Cape Town.
Interesting. So it sets up a kind of local revenue sharing for that specific high-value area, acknowledging the city's role, perhaps?
Precisely. It embeds a specific financial deal for a unique geographical asset right into the national legislation. Shows the Act's capacity to handle specifics.
Okay, we've seen the power to dispose, the power to protect, handling old rights, specific locations. How is this whole system actually managed? Who does what? Let's talk administration and delegation.
Right. Sections 6 and 7 are key here. They show a clear structure for pushing power downwards, making administration more practical. Section 6 allows the president to assign his main powers, like the Section 2 disposal powers, or the Section 2A powers over private land rights to the relevant minister.
So the president doesn't personally sign off on every lease?
Heavens, no. That would be impossible. The power is delegated. And interestingly, Section 6 allowed this delegation to be backdated to April 1992, which likely helped smooth administrative continuity during the political transition around that time.
Okay, so power goes from president to minister. Does it stop there?
Not necessarily. Section 7 allows the minister to delegate further. They can assign powers or duties to the premier of a province or another member of the provincial executive council, or even specific government officials at national or provincial level.
But there's a check there, right?
Yes. Crucially, delegation down to the provincial level generally requires the approval of the relevant premier. So the province has a say in whether it takes on those responsibilities. It allows for decentralized execution, but with provincial consent.
And minister itself isn't static.
Yeah.
You mentioned the 2024 update. That affects who holds these delegated powers.
Exactly. The definition of minister in Section 1 is key. For a long time, it was primarily the Minister of Public Works, who handles government property generally. But a 2024 proclamation shifted things.
How so?
It transferred the administration of the Act, specifically concerning land reform functions and related powers, to the Minister of Agriculture, Land Reform, and Rural Development. It shows the system adapting the authority follows the specific government function. Land reform matters are handled by the Land Reform Ministry.
That makes sense. The administration aligns with the policy area. Now, thinking historically, this 1961 Act didn't appear in a vacuum. Section 9 and the schedule. That looks like a major cleanup operation.
Oh, absolutely huge. Before 1961, land disposal was governed by a real patchwork of laws, old colonial statutes from the Cape Colony, Transvaal, Orange Free State, Natal, plus union laws. It must have been an administrative nightmare.
So Section 9 repealed all those.
Dozens of them. The schedule lists them out, things like the Crown Lands Disposal Act, 1887 from the Cape, the Settlers Ordinance, 1902 from Transvaal. This 1961 Act was a massive consolidation exercise, creating one single national framework.
A vital piece of legal housekeeping, then. And how did this framework, created in 1961, interact with the massive societal changes and new laws later on, particularly post-apartheid?
That's addressed at least partially by Section A. It was added later, of course. It clarifies that this Act's provisions operate alongside, or in addition to, the abolition of Racially Based Land Measures Act of 1991.
So the old administrative machinery for land disposal didn't just get switched off.
No, it clarifies that the mechanisms of this Act continue, but they must function within the new constitutional and legislative reality established by laws like the Abolition Act, which aimed at land reform and addressing past injustices. It ensured the administrative process didn't block the social justice imperatives.
Okay, so wrapping this up, we have an act that gives broad power to dispose of state land, sets terms, protects state land absolutely from prescription, allows for flexible administration through delegation, and has had to adapt over decades of change.
That's a good summary. It provides the underlying legal mechanics for managing arguably the state's largest physical asset, its land. And the broad discretion it grants, particularly in setting terms and conditions, raises ongoing questions.
Right, and that leads us to a final thought for you, our listeners. Given that the president or the delegated minister has this wide power to set the conditions when state land is sold, leased, or donated.
And keeping in mind that this act had to incorporate and supersede laws dealing with historical land uses, some dating back centuries.
What criteria do you think are most critical today to ensure these disposals genuinely serve the public good? How should the government balance, say, the need for modern housing or renewable energy projects against maybe historical land reservations or conservation needs, especially using that power to set terms and conditions?
Something to ponder. That delicate balance between flexibility, historical context, present needs, and public accountability.
Thank you for joining us on The Deep Dive.
Hope you found that useful. See you next time.